Those spit wads up.
Have all this paper. Ready to go.
The more spit wads you throw, the more inaccurate it by our accounts will get.
You're live and you're recording.
Trying to make it so they don't have to come.
Right. Right. You're right. I probably should have thought about this differently.
We're the jury for the sake of this here.
Right.
Yes, we have two alternates.
Mm-hmm.
I can take off.
I mean, alternates still get paid, so we still got our credit, right? Of course, here's $10.
And if anyone's curious, High Point did not win their first round today. So sure, a lot of people put money on High Point.
They went up against Purdue.
What's that?
But the guy with the 15.
They did not get the hype.
That's what the bottom line was thinking.
They did
All
not
right.
win.
We wanted to, well, I guess we're recording. We wanted to welcome all of you to our CLE presentation today. I'm Judge Camacho, for any of you that may not know who I am, and this is Judge Sipe. We're glad that you're here, and I guess we will get right into the Fourth Amendment. So the Fourth Amendment reads, "The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized." So now that we have read this, I think it's pretty self-explanatory. So we can finish this CLE right now and you can all go. Couple of the words that are important, that, or at least that Judge Sipe and I believe are important. One word is people. These are personal rights. It is not the houses, papers, or effects that have the rights. These are the people. And also another one is unreasonable. And that will come into play in the things that we talk about in a few minutes. We also want to make sure that we all remember the Arizona Constitution. Any discussion of the Fourth Amendment could also involve the Arizona Constitution, which basically reads, "No person shall be disturbed in his private affairs or his home invaded without authority contrary to law." Even though the Arizona Constitution sounds broader, it's actually almost identical in its interpretation with the Fourth Amendment, with one exception, and that is that the Arizona Constitution protects more or has more protections against warrantless entries into homes than the United States the Fourth Amendment to the Constitution. So we wanted to suggest a process in evaluating Fourth Amendment issues. And so the first question that should be asked is, was there actually a search or a seizure as it relates to the defendant? or it could be the civil rights plaintiff in a 1983 action. So first look at that, find out whether there was really a search or a seizure at all. And then second, was that search or seizure done by the government? Or I'll get into that in a little bit. The next one is, okay, if there was a search, was there a seizure? Was there a valid warrant for that search or that seizure? The next thing is, if there was not, is there an exception to the warrant requirement? Or in other words, was that search or seizure reasonable? And then the last thing is, if there was no exception to the warrant requirement, there was no warrant, it was a search and it was done by the government, then is suppression the appropriate remedy? And we've been conditioned, maybe in law school, to believe that anytime there is a violation of the Fourth Amendment, that it's an automatic forfeiture or suppression of the evidence that's collected. And that is not the case. And so it's important to look into whether suppression of the evidence is an appropriate remedy. So I have a little flow chart here, and it basically does the same thing. Was there a seizure? If not, then the Fourth Amendment doesn't apply, and the evidence is admissible. And of course, this thing right here is right in the way. For there's an arrow that goes over like that. So, and then if it was a search or seizure, then was that search or seizure done by the government? If not, Fourth Amendment doesn't apply and the evidence is admissible. If it is, then the Fourth Amendment does apply. Then you look to see whether there was a valid warrant for that search or seizure. If there was, then the Fourth Amendment was not violated, the evidence would be admissible. If there was no warrant, then you look, then the Fourth Amendment, I'm sorry, if there was no warrant, then you look for an exception. If there was no exception, then the Fourth Amendment was, I'm sorry, if there was an exception, then the Fourth Amendment was not violated. If there was no exception, then the Fourth Amendment was violated, and then you determine whether suppression is the appropriate remedy. If it is, then the evidence must be suppressed. If not, then the evidence is still admissible. So that's just kind of a flow chart to think about evaluating these cases. So also, it's important to evaluate every act along the way in a step-by-step manner. So, for example, did the initial seizure violate the Fourth Amendment? For example, in a driving a vehicle, was there a seizure? Well, there was a seizure if you stopped the car, if the cops stopped the car, but was that initial seizure legitimate? Was it reasonable? Then the next question is, okay, was the investigation or continued seizure prolonged during the time that the officer was doing whatever he was doing? And then if there was a pat-down search, did that violate the Fourth Amendment? Was there a search of the vehicle? Was that a violation of the Fourth Amendment? And if any of these acts did violate the Fourth Amendment, then should the evidence be suppressed? So let's go with the first one. Was there a search or seizure as it relates to the defendant or the civil rights plaintiff? Let's start with the definition of a search. There's actually two tests that are talked about by the Supreme Court. The first one is the trespassery test, or whether there was a trespass. The next one is whether there was a reasonable expectation of privacy that the person searched or seized had. And I'll get into that in just a couple seconds. These tests are not exclusive. In other words, if there's a search that takes place under either of these two tests, then it was a search. And it could be just the trespassery or just the reasonable expectation of privacy. And that's according to the Jones case. And these are These citations do not have the full citations, so you'll need to read the case. And then, so the definition of a search trespassery test, a search occurs when the government obtains information by physically intruding on a constitutionally protected area. So that means, in a constitutionally protected area is what is included in the Constitution itself, a person, houses, papers, effects. So if there's a physical intrusion into one of those, then it is a search. An example might be if you physically intrude into the person's body by sucking their blood out and getting a blood sample, then you trespass onto that person. Example. So police officers without a valid warrant place a GPS tracking device on the undercarriage of the defendant's car and use it to gather data about the car's travels. Is that a search? And I had this PowerPoint earlier so that I could just press the button and it'd be a surprise what the answer is, but unfortunately that's not the case. So yes, that would be a search because they trespassed onto the person's car, which is an effect owned by the defendant, and that's according to the Jones case. And then the second definition is reasonable expectation of privacy. A search occurs when an expectation of privacy that society is prepared to consider reasonable is infringed. All right, and let's go to an example of that. So an undercover officer enters an adult bookstore during normal business hours and purchases 2 magazines that are alleged to be obscene. The defendant argues that the officer's entry into the store and is looking through the pornographic magazines is a search. Is this a search? And the answer, according to the Supreme Court, is no, because there was no reasonable expectation of privacy in a display area of a store during normal business hours. Also, it wasn't a trespass because they invited people into that store so that they could peruse the materials in that store. And so it would not be considered a search at all, and the Fourth Amendment does not apply. And then seizure of a person. So only when the officer, by means of physical force or show of authority, has in some way restrained the liberty of a citizen, may we conclude that a seizure has occurred. So there actually has to be some physical force or show of authority that is used to actually restrain the liberty of a person who is seized. And without revealing the next example, let's say, for example, a person is driving down the road, police officers, without any justification, the guy's going the speed limit at the time and is in the lanes and not doing anything wrong. Police officers light him up. The guy says, forget that, I'm taking off. So he goes off a high-speed chase with the officers. They chase him down and the guy ends up crashing. And then the officers search the vehicle, find drugs, maybe other contraband. And the guy says, hey, I was seized improperly. That was wrong. Was that a seizure? Do you guys want to guess?
No.
It wasn't. And that's according to State versus Gonzalez. That's an Arizona case. So, and then seizure of property. A seizure of property occurs when there is some meaningful interference with an individual's possessory interests in that property. And the example that is given is that a renter of a mobile home was behind in his rent and faced eviction because the eviction process was taking a little bit too long. The landlord decided, I'm just going to call the sheriff's office and they're going to help me to remove this property or this mobile home from my lot. And the sheriff's deputies show up, help them to get the mobile home off the property. And the guy, the renter, sues the sheriff's office and says that that's a violation of his civil rights under 1983. Was this a seizure? And it was a seizure. It was a removal of property that interfered with the possessory rights of the home. And then the next one is, there a search that was done by a government entity? And basically, the bottom line is it has to be the government or someone a private individual that does something at the behest of or helping the government in an investigation. If it's just a private person that is not participating or not, is not part of the government or is not doing it at the behest of the government, then the Fourth Amendment does not apply. And then there's a couple tests to determine whether or not a private individual is doing it at the behest of the government. First is whether the government had knowledge of it. And the next one is the intent of the person performing the search. There's a couple examples that I was going to give, but I'm running out of time and I need to make sure that Judge Sipe has enough time to do his portion of the presentation. So I'll turn it over to you.
These presentations are an hour and a half long. With two presenters, we're breaking it down 45 minutes a piece. And the way we're breaking that down is our first part will be 15 minutes, our second part will be 30 minutes, and it will be pretty difficult to get through everything that we want to talk about, but we'll do the best that we can. So I'll be talking about search warrants, and I'm not going to read to you again, or the U.S. Constitution, the Fourth Amendment. The word that has always stood out to me is unreasonable. Because when you really break down the Fourth Amendment and the Fourth Amendment issues, really it's reasonableness is what we're looking at. And I'll show you how the case law uses that word constantly in analyzing issues. Reasonableness. So that's what we're really talking about. And I realize it's not easily defined what is reasonable. And sometimes I think to myself, I should have been a scientist because I really like absolutes more than concepts like reasonable suspicion, but that's fine. And for those of you who may not know my background, I know we have some people on Zoom and people here obviously in person. I've been on the criminal bench now for approximately 10 years, 2 months, and 20 days. And prior to that, I was a defense attorney in Mohave County for 26 and a half years. And I really enjoyed that part of my professional life. And I litigated a lot of suppression issues. I always enjoyed the Constitution when I started learning about it in law school. I was really glad I worked in the area of law where you're dealing with constitutional issues on pretty much every single case. And I litigated a lot of issues, and I really enjoyed raising and litigating Fourth Amendment issues. I really enjoy these issues as a judge. I am surprised that I actually don't see as many motions suppressed as I anticipated. And Mr. Carpinelli, before we began, asked me, well, at this presentation, are we going to be filing more motions? Absolutely. And I'm basing the lack of motion filing based on the frequency I filed motions. So I'm really basing it on that, but I really thought I'd be doing a lot more suppression hearings as a judge, which I really enjoy doing. But again, when we talk about the Fourth Amendment, it's really reasonableness that we focus on. And let's talk about search warrants in about 10 minutes. And I'll probably use some of my 30-minute time when I talk about vehicle stops and searches to finish up on the search warrant, because it might be interesting for you to learn what we go through when we're notified that the officer wants to see us on a search warrant, or you answer your phone at 3 a.m. So as you know, for a search warrant to issue, there must be probable cause to believe that offense has been committed and the evidence exists in the place for which the warrant is sought. And some of you may not know this, but there's actually statutes in Arizona that govern search warrants. That's ARS section 13-3912 through 3913. So we all know that there must be probable cause. Again, one of these concepts that you can't really measure objectively. So what does probable cause mean? Probable cause for the issuance of a search warrant exists when there's facts and circumstances presented to the magistrate which are based on personal knowledge or trustworthy information sufficient to warrant a person of reasonable caution. Again, the word reasonable applies everywhere in Fourth Amendment analysis, to believe that seizable items are located on the premises to be searched. And although these are concepts that are somewhat hard to identify, when we review affidavits in support of a search warrant, it can actually be fairly easy. I stopped a person who was driving a motor vehicle, and there were 10 pounds of cocaine in his trunk, and we found 3 cell phones. So there's probable cause to search the cell phones. The search warrants that I used to see a long time ago, which we don't really see that often anymore, is the CI that was in somebody's house. They bought drugs in the last 2 days, and probable cause there's still going to be drugs in the house. So sometimes probable cause issues are pretty easy to determine. Sometimes they're not, which I'll talk about in a few moments. And of course, when you're challenging a search warrant, the presumption exists in favor of the validity of the search warrant. Therefore, the defendant always has the burden of proof to prove that the warrant was not valid. And in reviewing the validity of the search warrant, the court is required to consider the totality of the circumstances. I'm sure everybody knows about the Gates opinion. Now, when I went to law school, before probably all you were born, we first had to learn about the Aguilar-Spinelli test. Did you guys still learn that in law school? No? Okay. One person. All right. Really? All right. Well,
Youngest, I would have.
well,
They teach you it, and then they teach you about why it's wrong.
Yeah.
before Illinois versus Gates, there was the Aguilar-Spinelli test. That was something you could objectively measure. That if there was a search warrant based on informant information, you had to prove 2 things. One, the basis of the knowledge. In other words, how did this informant receive this information? And number 2, veracity. You know, you have to prove that the informant was reliable and believable. And it was a 2-pronged test that had to be strictly followed. And without getting into politics, I think the makeup of the U.S. Supreme Court changed a little bit. And then we came out with Illinois versus Gates, which says, no. It's just the totality of these circumstances, another great concept that's hard to objectively measure. It's not just 2 factors, and that's it. We have to consider the totality, because probable cause deals with probabilities, not certainties, and the probable cause standard is a practical, non-technical conception. So we went from Aguilar-Spinelli to Gates. Just the totality of the circumstances is all it takes for a probable cause. And of course, the warrant has to be particular. That's obviously specifically in the Fourth Amendment, because one thing we're not going to allow is a general exploratory rummaging in a person's belongings. The Fourth Amendment requires the search warrant particularly describe the things to be seized. Only a warrant that particularly describes the place to be searched, the person or things to be seized, is valid. A description is sufficiently particular when it enables a searcher to reasonably, again, the word reasonable, ascertain and identify the things to be seized. When I challenge search warrants as a defense attorney, I always raise this issue that the search warrant was too general because there's always language in there about, quote, any evidence. And so I was never successful, but I still raise that in all of my motions to suppress because I'm not a big fan of that particular language. If you're looking for drugs or drug paraphernalia or weapons, then the warrant should actually be very specific in that regard, as opposed to, quote, any evidence. And a case I had years ago as an attorney, not that I am bitter, but a long time ago, I had a case that involved a search warrant where it was very particular. The search warrant was looking for 3 specific things of stolen property, like a generator, a drill, and maybe some tools. Very specific. Search warrant was for the residence and for the defendant's vehicle and his person. So when the team was on the way to the residence to execute the search warrant, they saw the defendant driving. They stopped him, executed the search warrant, and found all 3 things they're looking for. What's that mean? Probable cause no longer exists because you have in your possession the 3 things that you're looking for and the only 3 things you're looking for. Nevertheless, they went to the residence and executed the search warrant and found drugs, those additional drug charges. And I challenged that, thinking, well, this could be an easy win for me. And the judge denied the motion. The judge still felt there's probable cause, which is kind of confusing because they had the things in their possession that they were looking for. And I mentioned earlier that I really enjoyed litigating search and seizure issues. And believe it or not, from time to time, the judges actually did grant the motions. And I know there's always this kind of innuendo that we never grant motions. Well, no, we do. And the other thing you have to think about in search warrants, of course, is a good faith exception. So even if a judge does not find probable cause, and there's been times on motions to suppress, I have not found probable cause, if the law enforcement officer obtains evidence in reasonable, again, good faith reliance on search warrant later invalidated, the exclusionary rule does not apply. And of course, that's United States versus Leon. And when I authorize a search warrant, and I'll get into this in a couple of moments, I want the officers to leave my office or my house at 3 in.the.morning with complete confidence they have a valid search warrant. And that's really what good faith is, because the exclusionary rule doesn't apply if the officers acted in reasonable good faith, because the rule of exclusion is to basically punish law enforcement for not following the Constitution. And if they were acting in good faith and didn't know it was a bad search warrant, then punishing them would not be consistent with the 4th Amendment. So if a law enforcement officer acts with a objectively reasonable good faith that their conduct is lawful, deterrence is unnecessary, and the exclusionary rule does not apply. And I don't know if everyone knows this or not, but there's also a statutory good faith exception in Arizona ARS section 13-3925C. You got 4 more minutes, which says the trial court shall not suppress evidence as otherwise admissible in a criminal proceeding if the court determines that the evidence was seized by a peace officer as a result of a good faith mistake or technical violation. So those are 2 things that you should always think about when you're reviewing search issues, is good faith. There's the kind of the federal statute and the state standard. Yes.
What would be considered a technical violation for the Arizona statute?
Well, funny you asked. Now, good faith mistake has a definition: a reasonable, that word again, judgmental error concerning the existence of facts that, if true, would be sufficient to constitute probable cause. And technical violation has a definition, means a reasonable, that word again, good faith reliance on 1, a statute that is subsequently ruled unconstitutional; 2, a warrant that is later invalidated due to a good faith mistake; 3, a controlling court precedent that is later overruled, unless the court overruling the precedent orders the new precedent to be applied retroactively. So Arizona has these definitions as well, along with, again, more the federal standard of good faith, basically reasonable reliance on the validity of a search warrant. And so I'm gonna turn my time back over to Judge Camacho. It's about that time. And I'll come back for 30 minutes to talk mostly about vehicle stops and seizure issues and search issues. But before I do that, I do want to talk about the practical application of search warrants. In other words, what we go through and how we review affidavits that come to our attention.
And Judge, I just, on this issue that you started with of not seeing motions to suppress, back in our day, not to be the old guy in the room, but back in our day, there were times when you would file motions to suppress, and I would say it was in not 100% of the cases, but let's say 99% of the cases. And if you lost that motion to suppress, which you did not always lose the motion to suppress, but if you did lose that motion to suppress, a lot of times your client and you would be like, hey, we want to take the deal. And we would enter the deal that day in front of the judge. The problem that we have today is that's not the practice. The county attorney's office will withdraw all offers if a motion is filed. So I have to advise my clients, well, that's a great issue for a search warrant, but first we have to figure out if you want the deal. Assuming the state's made a deal, which is, you know, kind of a 50-50 thing these days.
And I understand that. And when I say that I don't see as many search warrants or I don't see as many suppression issues that come to my attention, I'm not saying that, to be clear, negative in any way, shape, or form. I'm just simply comparing that to the frequency I filed motions. And when I filed motions, I tried to file them fairly early on in the case as well. I didn't let the case, drag on for several months. I tried to file my motion fairly quickly. And yes, things were different. I don't recall ever filing a motion to suppress with any fear that if I didn't prevail, that was going to in any way, shape, or form impact my client or impact the plea offer. And interestingly, if there were times where a prosecutor actually made a plea offer deadline, the deadline was still open, or the offer was still open so long as we had a suppression here before the deadline. So we would do that quite a bit as well. So I strongly disagree with any policy that in any way, shape, or form punishes anybody for exercising their constitutional rights and challenging search and seizure issues. But I realize that that can and probably does happen.
All right, so we've talked about the first three ones. Next one is if there wasn't a warrant and there was a search done by the government, then is there an exception to the warrant requirement? Or in other words, was that search or seizure reasonable? And so there are several exceptions. There's actually more than the ones that I have listed on this slide. One is consent. Another one is from the Terry case, Terry versus Ohio. Search incident to a lawful arrest, exigent circumstances, plain view, inventory search, automobile exception. So these are some of the exceptions, and some of them kind of overlap in some ways. So the consent one, the test is, was the consent voluntarily given? Was this a voluntary consent? And as I say in the third part, subsection C, it says consent cannot be coerced expressly or implicitly. So a consent does not work if the officer is holding a gun up to the head of the person who supposedly consents. The burden, the state has the burden of proving the voluntariness of the consent. So it's the state's burden to show that a person consented voluntarily. And voluntariness is determined, again, as was said earlier, by the totality of the circumstances, the amorphous totality of the circumstances standard. And then express consent is not required. In other words, a court or the officers can infer consent from the context by what was said, what was done, how a suspect may have reacted in a situation. It can be inferred. Third-party consent. A third party who has apparent authority to consent may grant consent to a search. Probably can't grant consent to a seizure of another person, but to a search. However, if the suspect or the defendant is present when that happens and objects to the search, then the third-party consent to the search is not reasonable, at least as to that defendant. And the scope of the consent. So the scope of a search is based on conduct. Consent is measured by what a typical reasonable person, hear that word again, would have understood by the exchange between the officer and the suspect. A suspect may limit the search of the scope. And when an official search is properly authorized by consent, the scope of the search is limited by the terms of that authorization. So an officer may only search where the person consented to the search, what for, what to look for, how long the consenter allows that search to take place. And again, it's measured by the totality of the circumstances in determining what was actually consented to. And unless there's an axon camera, then it may end up being a situation where the person who consented or supposedly consented and the officer get on the stand, which is one of the reasons why axon can be very valuable. And then the next exception is the Terry exception. So what does Terry actually allow? It allows an investigatory stop, which is a seizure, and it allows a frisk of a person, which is at least limited search of a person. So the standard for the stop or the seizure is that it requires that the officer has a reasonable suspicion that criminal activity is afoot. A frisk requires that the seizure was lawful. So the seizure of the person has to be lawful to start out with. And then the officer must reasonably suspect that the person is armed and dangerous. The parameters of a Terry stop. An investigative detention must be temporary and last no longer than is necessary to effectuate the purpose of the stop. And Judge Sipe may be getting into this a little bit, but for example, if you stop a vehicle, there's a Rodriguez case that basically says that you have to, you can't go beyond the purpose of the stop unless while doing the purpose of the stop, other reasonable suspicions start to develop. And while the seizure is taking place, the officer may ask questions to verify or dispel any suspicions that the officer may have. If those suspicions are dispelled, the seizure must end. The person must be permitted to go on their way and drive off or walk away or wherever they want to go. However, if an officer, while doing the investigation, trying to diligently investigate or dispel these suspicions, if that officer comes across evidence that raises new independent reasonable suspicions, the officer may continue to go down those avenues, whatever they may be, until either the officer has probable cause to, or has sufficient to arrest the person, or those are dispelled as well. A search incident to a lawful arrest. So for a search incident to a lawful arrest, first of all, it has to be a lawful arrest. I know that sounds silly to say that, but the arrest has to be lawful in order for that exception to apply. Also, the search must be limited to the arrestee's person and the area within immediate control of that arrestee. And the search must be contemporaneous with the arrest. And we'll go through a couple examples of that. So, okay, so the next one is search incident to a lawful arrest. First question is, was there arrest at all? Was it actually an arrest? And second of all, was it lawful? So there are factors, it's a totality of the circumstances, but there are factors in helping to determine whether there really was an arrest. For example, if their movement was curtailed, if there was a display of authority, if the person was handcuffed, if they read Miranda warnings to the person, then those are factors that would indicate that the person was indeed arrested. Then, was it lawful? So there are reasons why a lawful arrest can take place. For example, for a felony, all they have to have is that it was a felony, that there was probable cause to believe that the person arrested committed that felony. For a misdemeanor, it's the same thing. There's a misdemeanor that has been committed, it's in the officer's presence, and there's probable cause to believe that the person to be arrested has committed that offense. Traffic violation, that's a violation of Title 28, and occurred immediately prior or immediately following the accident. Then the last one, that always got me. It says a misdemeanor or petty offense, and there's probable cause to believe that the person to be arrested has committed that offense. There's an actual exception that says that the person can be released under a lot of circumstances. So but it's still a lawful arrest if that's the case. And then search incident to a lawful arrest, the arrestee's person or within the immediate control. So the search must be limited to the arrestee's person, the area of their immediate control. So for example, in this room, if Judge Sipe were a law enforcement officer and were to arrest me, those of you in the back of the room, your stuff would not be subject to search by Judge Sipe because you are not within my immediate range of control.
Officer Sipe.
Officer Sipe. And then also the purpose of this is to protect officers and to ensure that, you know, the person being arrested can't access evidence or possible evidence and destroy it, somehow throw it towards the nearest toilet and somehow get it to go down the drain or anything like that. So that's the purpose of this exception. So an example is and this is an actual, the Chimmel case, it's a very interesting case to read. In that case, the police went inside the house, they arrested him, they had a valid warrant for his arrest, and then they decide, well, okay, incident to the arrest, we're gonna go into all bedrooms. This is in the living room where he was arrested. We're gonna go into the bedrooms, we're gonna go into the garage, we're gonna go into his attic, we're gonna search all these places. And they find evidence of the crime that they had come to arrest him for. And he files a motion to suppress. The Supreme Court, it actually made it to the Supreme Court. I don't know how it even had to go that far, but anyway, it went to the Supreme Court and they said, no, it has to be within his, within the area that he could actually reach a weapon or where he could actually get these items of evidence that perhaps could have been destroyed. So it's not within his immediate control. Then another example, the Riley versus California case. The police lawfully arrest a man for driving on a suspended license. They search the defendant and find a cell phone in his pocket. So the pocket itself, or the cell phone, is probably in a place where it's within his reasonable access, reasonable control. He could probably pull it out and do something with it. I don't know, hit the officer over the head with it, or I don't know. But at any rate, the cell phone wasn't the issue. But what happened was that the police officer pulled out the cell phone, started to scroll through the cell phone, and found incriminating evidence against the defendant while scrolling through this phone. He didn't have consent from the defendant to do that. And then he files a motion to suppress, and the Supreme Court in 2014 says, no, the cell phone itself does not, especially after it was taken into the custody of the police officers, that the information within the cell phone did not pose an immediate threat to anyone, and wasn't likely that he was going to destroy the contents of that cell phone because it was actually in the police officer's control at that point. So the scrolling through the cell phone was a violation of the Fourth Amendment. And then another example, and this is an Arizona case, person is arrested or is stopped by security people at a grocery store. They secure him in one of two rooms in a security office. There's a backpack that he has that they put in the other room. The police come in and read Miranda, they question him, and then they go out into the other room where the defendant is not. And then they say, oh, this is search incident to a lawful arrest. So they pull open the backpack and start looking through it and find drugs and firearm and stuff like that. And the Arizona Court of Appeals says, no, that was not contemporaneous to the arrest, first of all, and it wasn't within the reach of the defendant at the time that they searched it. And I'm beyond the time.
No, you're half-hour block.
Am I half-hour block right
Yeah,
now?
you're half-hour block, yeah.
Okay. Okay. Next one. Yes.
It's somewhat related to that one. How about you'll just stop, they arrest the person, so they're already not able to access their bag or backpack. Now the officers would likely get into it another way, but during that time, another person pulls up as well in the car, and the officer is going to hand that bag that was in the car after he's arrested to the other person in another car. How about that with the officer's safety, checking the bag before the officer hands that bag over to the person who's not going to arrest that when it was.
So your question is if when the officer is going to be handing it to someone else, and I hope this isn't an example of a question that's going to be in a motion to suppress that's going to be in front of one of us.
There was something similar quite a while back.
So the officer is allowing someone else to take possession of the
That
backpack,
wasn't
then he should not have any officer concerned safety issues if he's allowing that person to take possession of the backpack. That's my analysis.
Okay. Okay. So exigent circumstances. One of the well-recognized exceptions applies when there are emergency situations that make the needs of law enforcement so compelling that a warrantless search is objectively reasonable under the Fourth Amendment. And so for exigent circumstances, first of all, it requires a compelling need for official action. So there has to be some compelling reason why this search or seizure needs to take place. And there needs to be no time to secure a warrant. And it's determined by the totality of the circumstances. the classic example used to be that what's called evidence, and I can't pronounce it correctly, evidence, where a person is driving allegedly intoxicated and the officer is in the middle of maybe wiki up and there's no judge anywhere around, and this is before there are cell phones, and the officer says to himself, there is no way that there's going to be any evidence in this person's blood by the time I travel up, and this is in the middle of the night, by the time I travel up to Kingman, knock on 5 judges' doors and hope one of them answers the door, present them with a warrant, and then drive back to Wickiup and execute this warrant. And so the idea of that used to be that because this blood evidence would be going away, all of the alcohol would be out of the system by the time the officer got a warrant and was able to execute that warrant. Do any of you think that's a situation now?
Do electronic warrants for those.
That's what I'm saying. Yes. So they have electronic warrants that are available anytime, day or night. They have judges that are available. Some of them wake up when they're contacted. And so they're able to get warrants for that. But that's used to be one of the classic examples of that. So there are other examples of exigent circumstances. The Michigan versus Fisher case was where law enforcement needed to provide emergency assistance to an occupant of a home. Let's say, for example, they call 911 and the officers rush in to help this person in the home, and they find a bunch of drugs. Or the hot pursuit of a fleeing felon. So the officers are running after this person. The fleeing felon runs into a meth stash house, and while they're hot pursuit of him, and the officers decide, you know what, forget this fleeing felon. I see 200 pounds of methamphetamine. We're going after this guy here. And then another example is officers decide that they're going to help the fire department to put out a fire. Not exactly sure. That was 1978. So at any rate, they run in to help put out a fire, and then they find some incriminating evidence. So it's exigent circumstances. And then imminent destruction of evidence used to be like the blood example. Another exception is the plain view exception. If police are lawfully present and see evidence of a crime in plain view, they can seize it without a warrant. This requires that the officer has a legal right to be in the position to have that view, and that incriminating nature of the evidence is immediately apparent. So you have to be lawfully present. It has to be inadvertent discovery. In other words, the officer cannot know that the evidence is there and just act like he just happened to be there. And then it has to be in the immediately apparent to the officer that it's incriminating evidence. And then the officer has to have lawful right of access. And I'll get into that in just a second. So lawful presence, the officer must be lawfully present at the location where that officer sees in plain view whatever it is that the officer sees. the initial intrusion or wherever the officer is, he has to legally be there. So it could be justified by a warrant, an exception to a warrant, or other circumstances authorizing the officer to be where that officer happens to be. One example would be if the officer is on land where he's allowed to be and sees over or through a chain link fence that there is some contraband, then that would be plain view. And then it has to be inadvertent discovery. The officer cannot know in advance that the evidence is there and intend to seize it, because that would require a warrant. And then it has to be immediately apparent to the officer that it is contraband or otherwise subject to seizure. The officer can't just have a little hunch or anything. It has to be immediately apparent to the officer that it is indeed something that's incriminating. And then lawful right of access. So, for example, an officer can see what's on the other side of a chain link fence, and it can be plain view to them that it is contraband. But in order to get into the defendant's yard, they'd have to get a warrant to actually get in there to do it. Yes.
So for the inadvertent discovery requirement, how, I guess, stringent is that it is inadvertent? So if they have a hunch, they enter a house for a different reason and they're like, well, I'm pretty sure this guy has the stuff, and they see it.
I don't know.
I think it has to play out inadvertent, factually speaking.
Yeah.
Like, if you're in the house, because all of this stuff is subsequent to a lawful search. So it's like, you're in the house because there's a body, the officers are called, somebody may need help. You look in the front window and there's somebody slumped over. You don't get to search every bedroom. Maybe you get to search every bedroom because you need to sweep the premises for officer safety. But you don't get to look in every little nook and cranny that's smaller than human. So once they start doing that, I think you get in trouble.
And I think it goes to the reasonableness. So for example, the officer may have a hunch that there may be drugs in the house already. But if the purpose of it is to be able to claim the plain view without getting a warrant, then that would not work. And then I'll turn over time to
Okay.
Judge Sykes.
All right, for the last 34 minutes here, I want to go back and talk about search warrants, specifically what we do. And we review a lot of search warrants, a lot more than we used to. When I was first a judge 10 years ago, minus 2 months and 20 days, the most common search warrant was what I talked about earlier. An informant was in a house during a two-day period, saw drugs, probable cause, there's to go in there and search for the rest of the drugs. That was a common search warrant. We don't even see those anymore. Most of the search warrants are for phones, social media, GPS tracking, Google accounts. That's what most of the search warrants are now for. And we see a lot of them. And the typical process is the detectives know that most of us are in the office by about 8 and have court at 8:30. So detectives come by court admin about 8:05 looking for a judge. They also know that there's some judges that work through lunch. So they have nothing better to do than go see a judge who's trying to work through lunch, and they come by around noon. Other than that, they'll just call admin and say, well, we got some search warrants. When will be a judge be available? And then they'll find out which judge might be there, and then they could come in and see the judge at that time. Or you get the call at 2, 3, 4 in the morning. And that's fairly common. And I don't know about everybody else here, but if my phone rings at 2, 3, 4 in the morning, it's not good news. I'm not gonna answer my phone. No one's calling you at 4 in the morning to give you good news. I literally in my phone have the detective's numbers. So when my phone rings at 2 and I'm like, what is this? I look at my phone, oh, it's a detective. So my position is, as judges, we're public servants. We serve the public. And one of our duties is we must review search warrants because that's what the Fourth Amendment requires, that the judge has to review the search warrant and it has to find probable cause before they can issue it. That is our responsibility 24/7 as judges, whether we want to be walking up at 2 or 3 in the morning or not. And so if it's a detective, yes, come on over and I'll review the warrant. And again, that's very common. And not too long ago, they were at my house about 3 in the morning and I'm reviewing a warrant for an aggravated assault because a guy stabbed somebody. Then as I'm halfway through the affidavit, they get a call that the guy passed away. So now they have to leave my house, go back to the office and draft a search warrant for a homicide investigation and come back. And I don't have a problem with officers coming to my house at 2, 3 in the morning for me to review a search warrant. The only issue is that my cats like to lay on my paperwork and sometimes it's kind of hard to read it when cats are laying around everywhere when I'm trying to get some work done. So that's a typical scenario as to when we're contacted to review search warrants. And I don't grant every search warrant. I have absolutely denied search warrants. As a matter of fact, the Brady Shuffler case, they came to my office a couple of weeks after the incident with 2 search warrants. I rejected both of them. So there are plenty of times where I don't find probable cause or there's something defective in the search warrant and I said, I'm not signing this. And there was 2 occasions where I told the detective, I do not find probable cause, here's why, and they want to argue with me. And I try to explain to him, this is not a debate. You came to me, I don't find probable cause. Imagine if I grant your search warrant now, how do you get around good faith if I already told you there's no probable cause? And again, probable cause sometimes is a concept, if not a lot of times a concept that's hard to objectively measure. And I can think of a couple of occasions where I've declined to find probable cause, but another judge did. That doesn't mean I was wrong or that judge was wrong, but probable cause may be something different to each judge. And the first thing I do is I like to read the warrant. So I need to know exactly what it is they're looking for, who they're looking for, the property from, or the evidence from, what address, what location, what crime. I want to make sure that the warrant itself that I'm going to sign maybe is exactly the way it should be. Then, of course, I read the affidavit and everything has to match up. Now, if any of you have looked at the affidavits on search warrants I have signed, you'll notice that almost on every single affidavit, there's changes, there's corrections, there's errors. And if you ever see an affidavit from a search warrant I signed that has no errors or corrections handwritten in, it's because I made them go back to their office and redraft it. So the warrants often have issues. Let me give you an example. Again, phones are a very common thing that they search for. So it's not uncommon for the search warrant to ask to search the phone. All right, great. So I read the probable cause section of the affidavit. It talks all about the traffic stop, the investigation, etc., and never mentions the phone. And so I'm like, officer, the phone's it's not mentioned in here. Well, it is in the search warrant. I said, yeah, but there has to be some connection between the search warrant and for the phone and some information the phone's involved in this. That's pretty common that what they're searching for may not actually be in the affidavit and it has to be in there. Sometimes there'll be a specific vehicle they want to search. That's not in the affidavit. So either I'm gonna scratch it out of the warrant itself, or they're gonna have to write into the affidavit that vehicle is on the property, and here's why we think it's connected. So to me, search warrant is a pretty big responsibility for a judge. By the stroke of your pen, allow law enforcement to go in your house, go in your personal affairs, etc., and search. So I take that pretty seriously, and I've rejected quite a few search warrants, and most affidavits got to be changed, amended, modified. The ones that you don't see, they had to go back and redo. Yes.
When a search warrant is denied, is it like denied at that point and there needs to be a new stage of investigation, or is it like a mom said no, go and ask dad, you can just go to a different judge and see if they'll work?
Well, to kind of give you an example, I don't really want to get too specific, but again, probable cause is just a concept that's really hard to objectively measure. And probable cause may mean something different from one judge to another. And not a case where detective had me review an affidavit, and basically he wanted to search a person who was part of a motorcycle club. Some people might want to call a motorcycle gang, or maybe even a street gang, but he was part of a motorcycle club. And he was involved in an incident that had nothing to do with his motorcycle club. But the search warrant was to search his house, his records, his businesses, his cars, everything he owned, including businesses, for evidence of gang activity. And I said, no, this has nothing to do with gang activity. You know, this is a separate incident. Just because he might be part of this motorcycle club has nothing to do with this. I rejected that search warrant. That warrant was granted by a different judge. I'm not saying that judge was wrong. I'm just saying that we perhaps have different views of probable cause. So what they could do is they could go judge shop. They could do that, you know, or they can listen to what I tell them, go back to the office and redraft it and come back. Yes.
I have a question. Let's say you find probable cause, do you ever limit the scope of the warrant? Because you talked about, as a defense attorney, you hated the overbroad language, which is often still seen. They say all evidence, or they'll say all paper evidence, which means they can pretty much search anywhere. Do you ever eliminate that language from the warrant after you find probable cause? Because essentially, the officer's always going to be able to claim good faith, even though they're finding things that they shouldn't. Because the warrant is overbroad.
The way I look at that is the search warrant tells you what property you can search, what person you can search, what vehicle you can search. So to me, that limits it. You know, there has been some times, I think I had a case where it was a search warrant for the property and some outer sheds. So I was asking, well, how far are the sheds away from the property? And I said, well, what makes you think there might be evidence in the shed? So I struck that out of the warrant. So the warrant is our order, so we can do whatever we want with it. But there's been times where I have limited to some extent in that situation. That was one that I can think of. Yes.
Is there I guess, a paper trail of warrants that get rejected that would, because presumably that would be extrinsic evidence in the case.
Well, that's a good question, because I know from my experience, and I don't know if this is still the case or not, that the police officers always put in their police report, on this date, I went to see Judge Sipe, at this time he signed the search warrant, very specific. I've always wondered, when I reject a search warrant, if that's in the police report. So no, an officer can draft a warrant, it's not filed, bring me the affidavit, I can reject it. And if he doesn't try to present it to anybody, there's no paper trail of it. It's not a file or anything. I mean, maybe in their internal records, they keep it in their file. I don't know. But as far as the court goes, those no record. Yes.
You consider that evidence as part of the argument for bad faith that they're judge shopping?
Well, again, I always wondered when the couple occasions I know a different judge granted the warrant. Maybe I'm wrong. Maybe I should have granted the warrant. I'm not saying anybody was right or wrong. My interpretation of probable cause didn't exist, you know, but that could be an argument if, assuming the attorney ever finds out about that. So when you interview the police officer, you might want to ask him, by the way, why'd you go see that particular judge?
And Judge Sipe,
Because Judge Sipe rejected it. That's why, you know, I don't know,
that may also be Brady material.
you know. But it always intrigued me that they want to argue, you know, I'm like, how do you get around good faith? So anyway, and then the other thing that I do is after I read the warrant, I read the affidavit. Of course, he has to make changes and add things into it, etc. Once I'm satisfied probable cause exists, his T's have been crossed, lower J, I's dotted. Then he gets sworn in. We have to swear him in. And then he signs the affidavit, and then I sign the affidavit. I also, if you've noticed this, I also initial the bottom right-hand corner of every page of the affidavit. And my initial is just a letter B. The reason I do that is it's the officer's way of knowing I, in fact, have read that page. And I say that because I've seen evidentiary hearings where a question might be posed, well, how do you know the judge read the affidavit? Did he read it out loud? Did you see his eyes move? How long did it take them to read that page? So my way of letting everybody know I in fact have read that page is I initial it. Then after initial, I sign it and I put the time I signed it. Then I go to the search warrant, sign that data and time that. Typically, the time difference between the affidavit and the search warrant is 2 minutes. Now, one might look at that and say, what? It took Judge Sipe 2 minutes to read this 15-page affidavit. The time difference is reflected on how long it takes me to initial the affidavit, sign it, and then go to the search warrant. So again, I know some judges do it differently. You might see a 15-minute time period between the two times, which reflects how long it took to read the affidavit. I just do it differently. I sign one after the other, which takes about 2 minutes. So anyway, I love to get the calls at 3, 4 in the morning, but I know we're needed. I mean, these are always homicides. They're not calling at 3 in the morning because they made a traffic stop. These are all homicides. Someone just got killed. We got to get in the house. So I never respect that. And will always answer my phone when it's the detectives. Anyway, so my favorite subject, vehicle stops and searches. When I was a defense attorney, I think I filed a motion to suppress on almost every single traffic stop. I love challenging traffic stops. And I always felt a little bit conflicted because mostly the agencies were DPS. And I was always conflicted because I thought, you know, it seems ironic that I'm challenging the traffic stops and the search and seizure. What you did was wrong, discover this evidence. However, I do not discover this evidence, I don't get hired and I don't get paid. So it's kind of a little conflict there in my own mind. So the Fourth Amendment, of course, protects against unreasonable, there's that word again, searches and seizures. An investigatory traffic stop is a seizure, obviously, under the Fourth Amendment. Because an investigatory traffic stop is brief and limited in nature, an officer need only possess an articulable, reasonable suspicion based on the totality of these circumstances. The traffic violation has occurred. An officer who has observed a traffic violation, of course, has reasonable suspicion to initiate a traffic stop. There's really not a lot of issues when it comes to a traffic stop. The only case I can think of that's published that says a traffic stop was unlawful was the Livingston case. I'm sure everybody knows State versus Livingston. And as a defense attorney, I challenged a stop on I-40 because the officer stopped my client, doing 76 miles per hour in the 75-mile-per-hour zone. I challenged that, motion denied. So it's kind of hard to get around a traffic stop. And think about ARS 13-3883B. A peace officer may stop and detain a person as is reasonably necessary to investigate an actual or suspected violation of any traffic law committed in officer's presence. Suspected violation. So a violation of a traffic law provides sufficient objective grounds to stop and detain a motor vehicle. And the suspected language I see a lot in window tint cases, that I suspect that window tint is illegal. So that's why I stopped the vehicle. I didn't know it was illegal until I stopped the vehicle and got my chart out and compared it to the window. But because I couldn't see the suspect through the tint, I suspected that it was illegal. Now, prior to 1996, one of the issues we always raised was that the stop was a pretextual stop. That the officer already had a reason or motive to make the traffic stop, so therefore it was unlawful. Has everybody heard the term whisper stop? All right, so everyone knows what a whisper stop was. So then in 1996, U.S. Supreme Court in Wren versus United States says, no, the subjective motive of an officer does not invalidate an otherwise lawful traffic stop. So in other words, even if it's a pretext stop, even if it's a whisper stop, so long as there is a objective reason, reasonable suspicion of violation of the statute has occurred, then you're otherwise authorized to make the traffic stop. So we see cases all the time where a drug detective is on Highway 93. He's not there working traffic. He's obviously got information that there's a vehicle coming through that's going to have drugs in it. And so they see the vehicle, and there's always a reason to make a traffic stop. So despite the fact that the officer had a subjective motive to make the traffic stop, long as he can say it was following too close, speeding, hit the fog line twice, going too slow, whatever it is, then the traffic stop is going to be otherwise valid.
To be fair, defense should still ask if it was a whisper stop, because they would have to give you that disclosure. One would think pursuant to Rule 15. So it's worth asking, it's just not worth asking for this issue.
Also, if you ever have a case where there's money seized, you might want to try to figure out if the money was forfeited. If so, where did the proceeds go to? That might be something interesting you may want to find out sometime. So obviously you have a traffic stop, it's a detention, and to justify detaining a person for investigatory reasons, police officer must be able to articulate specific facts together with rational inferences from those facts reasonably warrant, again, that suspicion the defendant has committed a crime or is about to commit a crime. The facts and inferences must provide a particularized and objective basis for suspecting the particular person stopped of criminal activity. Again, totality of these circumstances. The court should accord deference to train law enforcement officers' ability to distinguish between innocent and suspicious behavior. That has always been troubling to me to some extent and hard for me to reconcile, because when I evaluate as a judge the reasons for the detention, in other words, the reasonable suspicion of criminal activity, I always try to find something that I could objectively measure. In other words, where are you going? Tennessee. What's the passenger say? We're going to Idaho. I rented this vehicle in California. No, it was rented in Oregon. You know, things like that I could objectively measure. But the case law requires the court to defer to law enforcement as well. And it's hard for me to really figure out where the line is. And I say that because I typically don't like to rely upon the officer's subjective interpretation of human behavior. I like to see something that could be measured objectively. And I had a case where it was a traffic stop and the driver was nervous, as that's pretty common, and there's plenty of case law which says nervousness in of itself is not a sufficient reason for the detention or reasonable suspicion in and of itself. So he was nervous, and then the officer asked him, "Where are you going?" He was stopped basically, I think on I-15 going back up to Utah. And he said, "Well, I live in Utah, and I went to Vegas for the weekend, and to see my girlfriend. I stayed at Circus." And the officer asked him about his employment. He said, "Well, I just work part-time." So the officer's reasonable suspicion was he was nervous. And because he only works part-time, I don't think he had the financial ability to go to Vegas for the weekend and stay at Circus. I thought that was the easiest motion to suppress to grant. And I thought to myself, Circus, I think they pay you to stay there. It's not an expensive place to stay. So I've never been reversed when I've denied motions to suppress. I got reversed 2-1. It was not published opinion, it was a memorandum decision, but 2-1, I got reversed. And I thought that was the easiest motion to ever grant. And the two judges, really, the decision made it very clear that I pretty much had to just defer to the officer, just defer to him. Because even in their opinion, they said, even the officer testified that it's too expensive to stay there if you just work part-time. And I just don't buy that. I just will not follow that standard where I have to just defer to whatever the officer says. I had an officer once I'm not making this up. You can think I'm making this up. I'm not making this up. As a defense attorney, I'm interviewing an officer about the traffic stop. I'm curious. You said in your police report, he's doing 75 miles per hour. Is that correct? That's correct. Is not the speed limit 75 miles per hour on Interstate 40? Yes, it is. How's that reasonable suspicion? Because most people on I-40 don't go 75 miles per hour. They go faster. So because he was doing the speed limit, that was suspicious. Not making this up. You know, you've all seen well, when he passed my location, he had his hands on the wheels and in a rigid position, you know, and didn't look over at me. All right. If he looked over at you, when he drove by me, he looked at me and that was suspicious. So I was thinking to myself, next time I go to a judicial conference, every time I see a DPS officer, I'm gonna sit there and stare at them when I go by. Wait a minute, I thought looking straight ahead was you know. So anyway, I just as an attorney, you know, as a judge, I just want something I can measure, you know, and so I've seen officers say, well, he drove by me took a sip of coffee as he drove by me. That was suspicious. You know, did you have a question?
Well, and I guess I was curious about that, the opinion where you were reversed there. Was it a matter of them saying that perhaps the defense had an expert witness or frankly, anyone come in and say, no, Circus is a dumb? Anyone who, you know, cuts grass a couple times a week can afford to say that for the week.
I was thinking the same thing, but the dissent made a good point. The dissent said, you guys did not follow the standard review. You're supposed to defer to factual findings. You didn't do that. You pretty much just placed yourself in the judge's shoes. So you followed the wrong standard review. And number two, he was right anyway. And I don't think, actually take that back. The state did file a petition for review at the state Supreme Court. They didn't accept review on the case. But that was one I was so confused about because I'm like, that was easy to grant that. And there's really nothing there to justify detaining this guy, but I go return 2-1. So it's really 2-2 because I agree with my decision. So it's really 2-2. Yes.
Does an officer's knowledge prior to a stop about a suspect, or does that factor into the totality of the
Well,
circumstances?
it should, because because you're obviously predisposed now to see things. It's kind of like when I used to do a lot of DUI cases, you know, when the officer pulls somebody over and smells alcohol, he's now predisposed to see signs of impairment, right? And so likewise, you know, I think it does predispose them to find a traffic violation or to come up with reasons to detain after the traffic stop is over. And, you know, this slide again, seemingly innocent behavior can form the basis of reasonable suspicion if based on training and experience. He can perceive and articulate meaning in given conduct that would normally be innocent to the untrained observer. And I do understand that. I understand that when an officer makes hundreds or thousands of traffic stops, I absolutely agree there's a baseline of behavior that you're accustomed to when it's a routine traffic stop versus somebody who's transporting drugs. I absolutely get that completely, but I still don't think that the judges should completely defer to the police officer and just accept everything that they say. I think we still need to analyze all the factors that are given to see if reasonable suspicion exists. And just so you know, it's not going to change my view on how I review these issues because I got reversed one time in granting a motion. If I still think a motion should be granted, it's going to be granted. Of course, everybody knows about the Rodriguez case where once the detention is over, law enforcement cannot extend a completed traffic stop in order to conduct a canine search, for that matter, anything else. Once the purpose or mission of the traffic stop is over, then the person has to be let go. So everybody knows about the Rodriguez case. A seizure is justified only by traffic violation and cannot be unlawfully prolonged the time reasonably required to complete the mission of issuing a ticket for the violation. Authority for the seizure ends when the task tied to the traffic stop are or reasonably, once again, should have been completed. So I think we're all aware of that, that once a traffic stop is over, then you have to let the person go unless there's actual reasonable suspicion. But, and as far as the canine goes, it's not unlawful if an officer already has a canine with them and during the traffic stop runs a car around the car, because that, of course, did not in any way extend the traffic stop. It's only if you have to wait for a canine unless the person gives permission. An officer's inquiries into matters unrelated to the justification for the traffic stop did not convert the encounter into something other than a lawful seizure, so long as the inquiries do not measurably extend the stop's duration. So you know the scenario, that make a traffic stop, they have the guy come out of the vehicle, they put him in the patrol car, and while they're completing the ticket, ever how long that might take, then they're asking the questions about the trip. And then when they want to go, when they go to quote, confirm the VIN number, then that's when they're asking the passenger questions as well, because of course that is not extending the traffic stop either. And getting close on running out of time. So obviously there's reasons why a traffic stop could be extended, obviously consent, and go into search. Obviously, search isn't to arrest. They may search and arrest these person in areas within immediate control, where the arrestee may gain possession of a weapon or destroy evidence. Don't forget about Arizona versus Gant. Don't forget about that. What does that case say? Law enforcement may search the passenger compartment of the vehicle and send to arrest only if it is reasonable, right, to believe the arrestee might access the vehicle at the time of the search, or if it is reasonable to believe that the vehicle contains evidence of the offense of the arrest. So I was surprised that I don't see more of these issues, and maybe they're just not issues out there. Maybe there really are not that many search and seizure issues out there to be brought to the court's attention. But remember, in Arizona versus Gant, they arrested the person for driving a suspended license. And so he's handcuffed, he's put in the back of the police car, they search the vehicle and sent to arrest. He doesn't have access to the vehicle, so obviously he can't pose any threat to the officer by getting a weapon from the vehicle. And there's no evidence of driving a suspended license that would justify you searching the vehicle and sent to arrest. So read Arizona versus Gant and think about the limitations to search incident to arrest. Obviously, the automobile exception allows a warrantless search of the automobile, including containers therein. If a police officer has probable cause to believe contraband or evidence will be found in the vehicle. So the common scenario is officers make a traffic stop, they're at the window talking to the person that was stopped, and you see the meth pipe on the floorboard. So obviously that's going to give them probable cause to search the vehicle. Canines. Obviously, if a canine alerts on the vehicle, that's probable cause to search the vehicle. And the case you should be familiar with is Florida versus Harris, because if it is a canine alert and you're challenging that, then the state has to produce records to show that the dog is qualified, is reliable, and real world records, however, are not the accurate records to establish reliability. It's really the controlled environment performance that is more important. And that makes sense, because if a canine alerts at a traffic stop and there's no drugs found, then it's going to be considered a miss out in the field. But the canine is not alerting on drugs. Canines alert on the odor of drugs. So it doesn't mean drugs were not in that vehicle at some point. He's simply alerting on the odor. So Florida versus the Florida case makes it very clear that it's not the real world records, as you might think, that are more important to look at, but the training records. And most of you have probably seen the training records of the canines, and the records are pretty solid. I mean, it's amazing how accurate the canines are in the controlled environment. And again, after the stop is over, obviously someone can consent to search, which people do on a very regular basis. You know, they have drugs in the vehicle, and that appears to be
Oh.
your last slide. So anyway, obviously, after the stop is over, you can consent to search. Probable cause could be developed to search. Reasonable suspicion could exist to then detain and bring a canine. So I'm open now, Mr. Carpinelli. I'm gonna see a flood of motions to suppress. And I can't complain about it because I warned you. But no, I really enjoy search and seizure issues as a judge. I really enjoy them as an attorney. And when I say I don't see as many as I thought I would be against, no criticism. Maybe there's simply no issues to raise. But if there are issues to raise, please do so. We enjoy them. And even as a judge, I've actually granted motions to suppress.
Thank you, everyone.
Any other questions? All right, thank you. Well, we just tap in for a bogey? What kind of cloud was that? Just joking, come on. Yeah, Greg, I think we had